Elliot Blumberg on behalf of Danny Cruz, the plaintiff, who I believe is attempting to come in via Zoom from the Middle East.
Good morning, Your Honor. May it please the court, Chris Kolumchek on behalf of Carrie Cruz, the defendant, non-moving party.
All right, Mr. Blumberg, I do not see your client in the Zoom waiting room right now. So how did you want to proceed?
Well, I guess we can start without him. I already spoke to him on the phone this morning, so I know he's attempting to get in. Again, he is either in some remote place in the Middle East, and who knows what time it is there. But I don't think we need to wait, Judge. I think the issues don't require any assistance from my client at this point.
Okay, so this is your motion, Mr. Blumberg. I know we've had some discussions of this on the record. Can you tell me where everything stands now? Has anything changed since our last meeting?
Yeah, sure, Judge. And again, the parties mediated this case with Jerry Shefflow, and the court's well aware he is a widely used mediator. We attempted to resolve all the issues, and in fact, at mediation, we thought we had accomplished that. But one of the issues that came up during the course of mediation was the division of a pension. And I know reading the defendant's response, which really doesn't address the issue, but rather whether it's appropriate for the court to learn about what was discussed in mediation. Our position is that an agreement was reached, and as it relates to my client's military pension, based on a mutual mistake. That pension entitlement by Mrs. Cruz would have been based on a 10-year marriage and 10 years of accredited service for my client. We all entered into that agreement on the basis that those were the facts. As it turns out, those are not the facts. My client, during the course of this marriage, did not have 10 years of accredited service. So the amount of spousal support that was ultimately awarded, the portion of the pension that was awarded to her was based on facts that were not correct. We think the court has the ability and obligation to remedy that situation. And ultimately, we're asking the court to conduct a brief evidentiary hearing to determine the facts that exist and her entitlement to some or any of that military pension based on mutual mistake. Again, we provided the court with a brief which I think addresses the issues of a mutual mistake. I don't see anything in the responses that even addresses those issues. So the court certainly has the equitable powers to review and modify a mediation agreement if in fact there existed a mutual mistake. And that's ultimately what we're asking you to do, Judge.
Thank you. Mr. Kolumchek?
Your Honor, obviously, we disagree. We believe that they're having second thoughts based on documents and discovery they had at the time, but maybe had not reviewed it or not reviewed it properly. I've been a judge advocate for 30 years in the Marine Corps, and I know for a fact the claim they make regarding this mutual mistake is not true, because under the 1010 rule, that has to do with the Defense Finance and Accounting Services ability to pay directly to somebody, a third party, for direct payments. But that does not affect at all Michigan court's ability to divide a pension. So if it was really only 9 years of accredited service, that just affects the ability of DFAS to send her direct payments. But the division of the pension can still be made, and is often made in the Michigan courts all the time. So it really has nothing to do with a mutual mistake. It's just that for some reason they think, oh, she's not entitled to this, because they both have military pensions. And what they did was they divided what they thought their worth was of both pensions, had none to do with the 1010 rule. And then all of a sudden he comes back and finds this, I don't know if he did a armchair lawyer thing and said to his attorney, look, she's not entitled to this. I want this reduced. And regardless, that's the problem. You start getting into this about uh, what went into the negotiations, and then the whole mediation agreement has to go out. And so the really only question is that your signature? And and my client never agreed that there was a mutual mistake. I don't know why he keeps saying mutual mistake, and they're basing it on discovery they had at the time of the mediation. They're saying, well, look at this document. And it's like, that's the document that was exchanged and both parties had at the very, at the very beginning of the discovery process. And so I just would say that this is a clear case where the agreement should be left alone. And, we should not reopen this can of worms.
And Judge, if I could just briefly respond, counsel
Sure.
wasn't even at mediation, so he doesn't know what went on. And we're not asking the court to rewrite the entire mediation agreement. It is a single issue based on a misunderstanding by both parties. Had the amount of money awarded from this pension, again, Mrs. Cruz is getting the entirety of her pension. Mr. Cruz, based on an understanding, as well as the understanding of opposing counsel at that time, was that the entitlement based on the years of accredited service would have granted her this portion of the pension. That's simply not what went on. That was not the understanding of the party. It was a mutual mistake. And I think the court has the ability to allow the parties to present testimony on that sole issue alone. Again, counsel's suggesting we're asking the whole mediation agreement be set aside. We're not. That's a single issue that both parties apparently had a misunderstanding that entitled her to something that she may not have been entitled to at all.
Okay, I've got some questions, Mr. Blumberg, and some of these, first of all, I want to make sure that I understand. So, I mean, they negotiated. Mr. Cruz, believed that she was going to be entitled to some portion of that pension. So as part of the negotiations, he agreed to give her $1,000 per month out of that pension.
Wait, let me hold you there for a second, if I could. He thought that her entitlement arose from the years of accredited service that he had put in. That entitled her to a portion of her pension. It turns out he didn't have 10 years of accredited service. I'm not in the military. I'm not a judge advocate, but I know enough that accredited service is a term of art. And frankly, there was a misunderstanding as to what years and what credit he received for those years. That's the mutual mistake. Certainly, Mrs. Cruz was in the military. She had an attorney that didn't understand that. And frankly, I thought that he had the 10 years that everybody believed he had.
But regardless of whether she's entitled to it or not, he negotiated to give that to her, right?
Based on an understanding there was an entitlement. It wasn't
right.
It wasn't a gratuitous act on his part.
No. But listen, here's the thing. So they went forward and they negotiated this whole agreement. And that $1,000 a month, which is $12,000 a year. I mean, we're not talking about a de minimis amount here. That was made part of this entire agreement. So, they went forward with that as part of what she was going to get out of the agreement. And so, I kind of understand where Mr. Kalamchek's coming from is if you're going to take that 12 grand out, I mean, if she would have known at the time that she wasn't going to get that, then the negotiation probably would have looked completely different. Or if he would have known at the time and said, no, I'm not going to allow you any portion of this pension because you're not entitled to it because I don't have the 10 years of service. I mean, I don't see how we can take that part out of it when the entire negotiation, was one big package of all of these things. How can we take out a $12,000 chunk and then somehow just renegotiate that? Because I think if I'm Miss Cruz at that point or her counsel, I'm going to say, well, if you're not getting this money, then we need to take a whole look at this entire thing, because that's part and parcel of the entire agreement. And then the other part of it is, you know, your client negotiated this as part of the settlement. Isn't it on him to know what he can negotiate away and what he can't? And why is it now Mrs. Cruz's problem that your client didn't understand what he was negotiating away when he did it? I mean, isn't he the one that bears the risk for that?
Well, let me address both of your questions, if I could. Ultimately, whether this was a mediation agreement or whether this was the result of a trial in front of your honor, you would have to determine in the scheme of things whether it was fair and equitable. If the court were to review the property settlement in this case and determine, as I think the facts show, that Mrs. Cruz was the greater beneficiary of the 16-year marriage. She got the home without my client getting any equity in it. She was getting spousal support. My client took on all of this financial obligation that she was relieved from. So aside from the issue of mutual mistake and whether my client should have known this, the fact is I think you still have an obligation to look at the entirety of the settlement, the mediation agreement, and determine, even though it may have been the agreement of the parties, it still has to meet the criteria of being fair and equitable. And I think a fair reading of that is that certainly it's not just $12,000. She got a tremendous benefit from this mediation agreement. So I don't know if did I address your question or not, Judge, or was I just ranting?
I mean, no, I understand what you're saying, but now it sounds like you're making the argument that there was a mistake, but then also it's not equitable to let her keep this amount, which is a whole different argument. And now, I mean, then I think we are looking at, do we have to renegotiate this whole thing?
My client believes that the mediation agreement benefited his wife. He was willing to agree to that. He also agreed, and what the record is clear, at least the mediation document is clear, what he agreed to in terms of giving her money from his pension. But it was based on the premise that she was entitled to that. We don't believe now with the facts as they now exist that she would be entitled to that. And that also brings in the whole equitable argument. So they are kind of hand in hand.
Okay.
All right. Just briefly.
Yeah, go ahead.
Again, he says the facts as they are now. Okay, we do not believe there was a mutual mistake of fact. There was a DD 214 that listed the eligibility of those years that both parties had. The other thing is that I think, and again, this is the problem of starting to dissect parties' intentions of a mediation agreement. But I believe that Mr. Cruz thinks that somehow the court no longer has the authority to divide that pension because it doesn't meet a 10-year requirement of DFAS for direct payments. And I can tell you that there's case law on it. This is very clear. The court does have the authority and does do routinely divide military pensions that may not meet the 10-year requirement for direct payments, and they require the individuals to make sure that they pay the ex-spouse. So this is not a question of he's discovered, oh, she never even rates this. She does rate it. She still rates what they were negotiating. The question is whether she gets direct payment from DFAS. And that's where the mistake, I mean, there's lots of mistakes here, but as far as what I've heard from counsel about how the law is with regards to this. So I think they're assuming that you have no authority to divide that 9-year pension or 9.5-year pension, but you do. And
I don't dispute that, Judge. That's not the issue. We know the court has the authority to do that. That's really not the issue that we're talking about, though.
Then where's the equity change? If it's all the same, and he has the authority to do that, then what has changed from mediation to today?
and again, I'll try to state for the third or fourth time, is that his willingness to extend that $1,000 a month from his pension was based on a misunderstanding of what her entitlement was. Again, she got the entirety of her pension. She got all of the equity out of the marital home. She's getting relief from all of these marital obligations, including those to vehicles that my client doesn't even have. In the scheme of things, it would not be equitable. It would not be fair, given the fact that now he's required to pay her $1,000 a month when it's now determined he may not have been required to do so.
Okay, all right. So I've had a few chances in preparing for this hearing over the past couple of months to go through the briefs of the parties. And then taking all of that into account along with the arguments of counsel here today. First of all, I don't think it requires the court to get involved in the fine points of military pensions and how things are divided and whether this qualifies for division or not. Number one, that's certainly outside the scope of what the court typically addresses. Number two, I think it comes down to what did the parties agree to, what did they not agree to. And Mr. Cruz engaged in, from what I could tell, arm's length negotiations. He was represented by counsel. At the time the mediation agreement was entered into, he was willing to give Ms. Cruz $1,000 from this pension per month. In my view, it doesn't matter whether she was eligible to receive it or not. He felt that that was a fair deal at the time when he entered into it. Whether she was legally entitled to a portion of that or not, he negotiated that into the agreement. And so whether or not ultimately she is legally entitled to share in it doesn't change the fact that at the time he felt it was fair and he agreed to it. Absent some kind of fraud or duress, which doesn't appear to be present here. A mistake, I don't find that there's a mutual mistake here. If anything, again, I find that Mr. Cruz had the obligation, if he was going to negotiate a benefit away as part of a divorce, to understand exactly what legally he may be entitled or required to provide her and what he could just agree to provide her. And so to the extent that there's some risk in that or some fault in that, that's falls squarely in my view on Mr. Cruz for not knowing what he may have been legally required to give her versus what he could negotiate to give her. And so I don't think Ms. Cruz should have to bear the burden of that. I also find that because this was part of the entire negotiation and entire agreement, given the amount here, I don't think it would be possible to just separate out this one term and somehow negotiate that, because Ms. Cruz presumably agreed to this agreement on the basis that that money was part of the entire package. So the court finds that the objection should not be granted. The court is going to order, because I don't find that there's any reason to set aside the mediation agreement here or any portion of it. The court is going to order that the parties finalize this divorce on the terms as they were negotiated as part of the mediation agreement. So the court is going to deny the motion. Mr. Klomchek, if you can prepare an order that reflects the ruling of the court today. And I don't know where that leaves us, if we just need to set a final date to take proofs in this case, Mr. Blumberg.
Yes, Judge, I already have a proposed judgment prepared, not knowing how you would rule today, but yeah, we just need to notice it for a final hearing.
Okay, all right, thank you. Mr. Klomchek, anything further from your side today?
No, Your Honor.
So we'll go on the record in Cruz versus Cruz.
Good afternoon, Judge Elliot Blumberg on behalf of the plaintiff, Danny Cruz.
Good afternoon, Your Honor. Chris Kolumchek on behalf of the defendant, and I do have laryngitis today. I'm sorry.
Okay. All right. This is set. I know we've been dealing with this case, Mr. Blumberg. I believe, if I recall correctly, you were having difficulties contacting your client. We're trying to get the judgment entered here. Mr. Blumberg, can you give me any updates on where things are at from your side?
Yes, Judge. I received a proposed judgment from opposing counsel or his legal assistant some time ago. I had responded in an email. There's just a number of provisions within this judgment that were never discussed and certainly never agreed to. So the judgment also references a uniform spousal support order, which has never been provided to me. So the judgment that I have does not comply with the terms of the mediation agreement, and it doesn't, it contains provisions that the parties never agreed to.
Judge, with regards to that, first of all, we're the defendant. We've been waiting for months now for the plaintiff to produce a proposed judgment. So we started the ball rolling by doing what we did. With regards to the uniform support order, he's supposed to produce that since he's the plaintiff and include it with the judgment. But that's going to be a uniform order. There's no reason not to sign the judgment. We all know what the uniform support order looks like. So we did this back in June 16th. We gave a proposed judgment after waiting week after week after week for one from them. And I have no idea what's going on or why this is taking so long. They never responded since June 16th, other than to say he would check with his client.
That's not correct. But Judge, if you want, we can go through this judgment and we can talk about all of the provisions that were never discussed, and certainly the ones that never were agreed to, including a mandatory arbitration provision. I don't know where they came up with that. It's never been discussed. And it's inconsistent with the provision that talks about this court having continued jurisdiction. I mean, there's just places in here that they just put in whatever they wanted. And I'm certainly prepared to either have a hearing on that, an evidentiary hearing, or we can go through it provision by provision, because it's just totally inappropriate.
Well, why are you waiting till now to say it for the first time? And with regards to the arbitrary, the arbitration, mandatory arbitration, that's for personal effects. Now, we do that all the time when they go to mediation so that they're not fighting over, hairbrushes in court. Now, all you have to do is strike it, and we would have said fine. But that's something that we put in our divorce judgments routinely. But to say it's somehow not purporting to what we've all agreed to is ridiculous.
You go to mediation, not binding arbitration.
No, that's just for personal. All right, strike it. We have no objection. If you're willing to sign it right now, strike that. Is there anything else you'd like to strike?
Yeah, there is.
Here, I'm gonna put, hold on a second. This is what I'm gonna do. I'm gonna put counsel into a breakout room. I'm gonna let the two of you hash this out. There's no reason why I need to listen to it or for it to be on the record. And then let's bring you back in, and if there are provisions that we can agree to, or if you guys can hammer this out now, I mean, I think everybody acknowledges that we need to get this done, and I don't know. I haven't seen any, what the proposals are. So I'm going to put counsel into a breakout room. I'm going to let the two of you see if you can hash this out. And if you can't, then we'll have to figure out where we go from there.
Judge, so you know, we did submit a copy of the proposed judgment in our motion to enter judgment. Because we have a motion pending today, motion to enter judgment at the same time as the status conference. And we have a proposal there. Yeah, okay.
No, I looked at that, but from my standpoint, I don't know what the agreements are between the parties, so I don't have anything to compare your judgment to know whether or not it comports with the agreement or not. I'm
sure we can hammer it out right now. It shouldn't take very long.
All right, so I'm going to put counsel into a breakout room along with the clients, and let's see where we go from there. Okay, we're back on the record in the cruise matter. Mr. Blumberger, Mr. Podrick, were we able to reach any agreements?
Yeah, Judge, I think we are. I don't know if, I guess what's being requested of you is you have a copy of the proposed judgment in front of you?
I do.
Okay, so some of these provisions are going to be crossed out in total, and there's going to be some revisions made to others. So do you want to go through page by page?
Can we make a record of it and then, since you're plaintiff's counsel, or, well, I don't know, however you want it, whoever, Mr. Klomjic already went through the time of drafting the judgment, whoever would be easier, but what I'd like to do, I guess, is make a record of it, have everybody agree to it here, to the language, and then have one of the counsel submit a clean copy for the court to sign.
Okay. Well, Judge, if you would turn to page 2 of the proposed judgment.
Okay.
We're under the provision of uniform spousal support order. It references the attached uniform spousal support order. We both acknowledge that hasn't been prepared, and I will be preparing that for the court.
Okay. Mr. Klomjic, is that correct?
Yes, Your Honor.
Okay.
The next real changes appear on page 5.
Okay.
The provision under escrow accounts going to be omitted.
Is that correct, Mr. Klomjic?
Yes, actually, the whole page is stricken.
That's right. The entirety
Okay.
of the arbitration clause is removed as well.
Okay.
Page 6 is fine in its current form. Page 7, we didn't really discuss in detail, and I need to talk to counsel about language that he put in there that, again, were never really discussed. And candidly, some of it may be accurate and some may not, but that page of the judgment is, from our perspective, not ready to be entered by the court.
Okay.
On page 8, there's going to be a revision to the provision that the paragraph that says, for purposes of qualifying the defendant, the member and former spouse acknowledged that they have been married for a period of more than 10 years, during which time the member performed more than, that should read, 7 years of credible military service.
Mr. Klomjic, is that correct?
Yes, Your Honor.
Okay.
And frankly, Judge, the remainder of the judgment's fine in its current form.
All right, Mr. Klomjic, is that correct?
Yes, Your Honor.
Okay, so here's how we'll proceed. I would like to have a clean copy prepared with regard to the language on page 7 regarding the military pension. Within 30 days, if counsel are not able to agree on the language under military pension, then I'm going to ask each counsel to submit in writing their proposed language for that. We're not going to schedule any further hearings. The court will, if there isn't an agreement and each counsel submits their proposed language for that, the court will adopt the language it finds most closely comports with the mediation agreement. I did look through the file. I do have a copy of the mediation agreement in the file. So I'll be able to make that determination. And then the court will enter a final judgment in this case within the next 30 days. Again, if there's an agreement, the court will enter it based on what the parties, the clean copy that's submitted. If there's not, then the court will, again, make its determination. The only thing now, since we've been on the record, everybody's reviewed it. We've got the agreements on the record that have been made with regard to the language here today. So in my view, the only thing that the court would consider any kind of further debate on is that language under military pension on page 7. And again, the parties, if they can't agree, will need to submit written proposals for that language. The court will make that decision without further hearing based solely on the mediation agreement and the submitted language. And then again, the court will enter that judgment within the next 30 days. Mr. Blumberg, do you have any questions or issues with that process?
Not that, Your Honor, but does the court records reflect that we took the proofs in this case? Because we're prepared to do that.
We did take the proofs.
Okay, thank you.
So really, it's just a matter of entering the language, the judgment. So, Mr. Klumjack, do you have any objection to that process to get this finalized?
No, Your Honor, none.
Okay. All right, thank you. That's all for today then. All parties are free to disconnect at this time.
Thank you, Judge.
Thank you.